Next, we hear from a lawyer representing the State University's Annuitants Association as they sue the state over the recently passed pension reform bill. This runs about 15 minutes.
Aaron Maduff, thanks for joining us on the Illinois Channel. As anyone who has followed Illinois politics recently knows, one of the really big issues that's kind of overhanging the state and overhanging this year's budget process to some extent is the question of a bill that was passed last year to reform the pensions, and that, as expected, was challenged in the courts. You are representing the State University Annuitants Association, which has some 200,000 members. Quite a number of them are going to be, obviously, I guess all of them, impacted ultimately by the decision of the court and whether what the reforms that were passed are or are not constitutional. So let's first of all pick up. There was a hearing today, a court hearing. Just tell us briefly what was the purpose of that hearing and what came out of that.
The purpose of today's hearing was to set a schedule for briefings and other activities that happen in the case. At the moment, what the court has done is said that it wants to deal with the question of class certification and has set another date for June the 13th when we'll take up further issues in terms of what the schedule will be.
Let's, again, just we'll walk through this a bit slowly. The lawsuits were brought. The State University's Annuitants Association brought a suit. What was the grounds for their suit?
Well, as you know, the Pension Reform Act, also known as Public Act 98599, takes a huge bite out of public pensions. It takes a bite out of public pensions across the state. SUAA represents members of the State University Retirement System. That is, people who are current or former employees of the state universities and community colleges. The State University Annuitants Association has brought its lawsuit for the purpose of challenging the constitutionality of the law as it's applied to members of SUAA, members of SURS, the State University Retirement System. There are 5 suits that were brought representing different groups, different organizations. There are different retirement systems that are affected. For example, SERS is the State Employee Retirement System. There are differences in those systems, and SUAA has brought its suit because the differences in the SURS system create a different impact, different damages, different injuries for SURS members than for people in other systems. And as a result, they also create different legal arguments as to why the law is unconstitutional.
Now, it seems to me, one of the question marks is there's been a stay on the implementation of the law until the judicial process can run its course. When the law was initially going to go into effect, and I think some aspects of the law were initially going to effect in June, but as I understand it, predominantly in July, the new fiscal year, that's now been put on hold. When the case is ultimately decided whether the law is constitutional or not, do we know what would be the effective start point then of the law? Would it go back to the initial targets of how the law was written, or would it go into effect after a decision was handed down by the court?
The very short answer to your question is that the stay will be lifted if and when the judge chooses to lift it, and the judge, by the way he granted the injunctive relief, the stay, indicates that he is not going to simply lift it in a way that's going to create mass confusion. To explain that, I think you need to know the background of the motions that created that led to the injunctive relief. But the short answer is that the judge wants to avoid confusion, and as a result, you can expect that he is not going to simply lift the stay and have it respond retroactively. That would be contrary to his intent and for the reasons that he gave for granting the stay.
And so there are a number of people that are impacted. They're working and they're affected by the law, whether it actually goes into effect or not. What would you say to those people? I mean, as far as they're wondering, should I stop working now or should I continue working because they don't know necessarily how they're going to be impacted? Can you give them any guidance?
Yeah, well, there are essentially 3 groups of people that you're going to be seeing. Those who are already retired obviously are not going to be making a decision about whether they should retire. Those who are not eligible yet to retire are not going to be making a decision as to whether or not they should retire. The narrow group that is significantly affected are those people who are eligible to retire and need to make a determination to do so, or not to do so. Of that, some of them would retire anyway, so they're not really affected. They're going to make their decision to retire. The big concern is those people who are eligible to retire, but who, without this law, wouldn't have looked to retire in the first place. The stay that we have in effect now should alleviate them of that fear, that need to retire immediately. The expectation is that the judge will lift the stay only if he finds that the law withstands constitutional scrutiny, and if he does, he's going to do it in a way that is not going to lead to mass confusion. So people should feel comfortable that the judge is going to be looking out for their interests in that sense.
What role would you play in this process?
We filed the first motion for injunctive relief for a stay. The State University Annuitants Association, as I said, has certain issues that are a little bit unique among the other systems because of the plans that are available to people. There are different calculations, there are different abilities that people have to make decisions. The result is, for example, we had one person that before we got the stay, if he had failed to retire by June 30th, he would have given up something on the order of $200,000 in a refund of excess contributions made to the system. With those people, it was very important that they retire immediately or they would suffer injury. The problem that we found was that SUAA Executive Director Linda Brookhart recognized that because the law is so complicated, even though we know that certain people would have to retire, the people themselves didn't know necessarily if they fell into that category. And Linda Brookhart's concern was that this created a kind of mass confusion, which would lead to a lot of people retiring early who didn't need to. The result was that we very quickly moved for injunctive relief, asking the court to stay the law altogether. And we filed that motion on May the 2nd. It took another week and a half for one of the other groups to file their motion. During the interim, we talked to the Attorney General and said, look, let's have certain things that we know we're going to agree on, and the rest of it we'll take up in terms of the motion for injunctive relief. On May 14th, last Wednesday, the court took up the motions for injunctive relief and, to our great relief, granted the injunction, staying the whole process. In so doing, he had to list out his reasons for granting the relief, for granting the injunction. Injunctions are not granted lightly. They have to be very carefully supported. And the reason that he landed on was exactly the concern that Ms. Brookhart identified, the mass confusion. And in so doing, he also says that we want to alleviate that confusion. We don't want people taking early retirement and making life decisions based on confusion.
Let me jump ahead. So, I mean, we're talking understandably about the State University Annuitants Association, but also impacted here are just the teachers' retirement system, just K through 12 teachers, everyone who might be impacted by
all state employees, state police, firemen, people who work in all kinds of areas of state laws.
So, just to make that clear. Now, let's talk about severability. In other words, can the judge, what would be your expectations? Can he strike down a portion of the law but allow the other aspect of the law to stay? He could, I suppose, just strike down the law in its entirety and we start all over again. Just talk to us from a judicial standpoint and the power of the judicial branch to impact the law. How would that decision be made or could be made?
A lot of that is dictated by the text of the statute itself and what the legislature intended. The law makes adjustments to a lot of different areas, things like effective rate of interest, which is going to be a confusing acronym, ERI, things like the retirement age, things like how we calculate the pension itself. There are 3 sections that relate to the automatic annuity increases or cost of living adjustments, COLAs as people know them to be. Those are separately severable from the rest of the law, but not from each other. So if the court determines that one of those COLA adjustments is unconstitutional, all of them fall. But they are severable from things like the retirement age, the effective rate of interest, which goes to the money purchase calculation, and actuarial factors, and other sections of the law.
And then another aspect, and we will wrap up here shortly, but another aspect is, since we don't know if the law is constitutional or not, none of the lawmakers know. How much money do they have to spend? And here we're trying to put together a budget. It's estimated that would save the state some billions of dollars a year and free up money for education or whatever else the legislature would want to spend it on. But right now the hearing is was held today and will be again coming up, is at the circuit level. Normally it would go circuit, appellate, and then Supreme Court if at all. But your expectation is, I think, that it would not go to the appellate level, that as far as the constitutionality of the ruling, because of the urgency of getting some kind of a decision, it might skip?
It's not necessarily the urgency. Urgency is a part of it, but we all recognize that with this kind of a constitutional challenge and the amount of money that's at stake, that we think it is very likely, and when I say we, I mean both the plaintiffs' groups and the Attorney General, very likely that the Supreme Court will take it up. There doesn't seem to be much point in spending time in the appellate courts to get an appellate ruling if the Supreme Court is going to take it up. Ordinarily, you would go through the appellate court because you have to get what's called permission for leave to appeal to the Supreme Court, and most cases are not taken to the Supreme Court. Your automatic right of appeal is to the appellate court. This case is important enough, has earth-shaking consequences, I think, for all of these retirees, which could be millions of people. I'm not sure what the exact numbers are. And for a large portion of money in the state budget, that we expect that it's going to be taken up by the Supreme Court. And as a result, I think that there will likely be motions to simply go a direct route of appeal, to the Illinois Supreme Court. And
lastly, when the Supreme Court, let's say they do take it up, which is expected, there's no time frame upon which then they have to release a decision. They could sit on it for a year if they wanted.
That's right. It depends upon the court's docket and who's in charge of it. There are a lot of factors that play in, how important it is for the court, in its view, to get an opinion out. I have seen appellate courts come out with opinions in a matter of a month. I've seen appellate courts take more than a year for opinions to come out. That is something that is unpredictable. The only ones who know would be the justices themselves.
All right. Well, Aaron Maduff, we appreciate you joining us and explaining the process.
My pleasure. Thank you.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.